Hello, great people. Welcome back to Global Happenings. Today, we're so excited to have you again. It was not an easy one for Festus Keyamo as the Federal High Court in Abuja released their sledgehammer on him over a case he brought before the court against Atiku Abubakar, the PDP presidential aspirant. Don't forget that some few months ago, Festus Keyamo had come up with an application and he had sought an order compelling the Economic and Financial Crime Commission, EFCC, ICPC, and the Code of Conduct Bureau to probe and prosecute Abubakar, that's Atiku Abubakar. But right now, it has turned up against him as he has been forced to pay a whooping sum of amount and classify as an errand boy by the court. This is quite interesting. But guess what? He's ready to fight back and he has rolled out the action. The next action is about to take. But first of all, let me give you full details of what transpired in court today. According to the news, the Federal High Court Abuja on Monday awarded a 10 million naira fine against Mr. Festus Keyamo, former Minister of State for Labor and Employment, for filing a frivolous suit against Atiku Abubakar, the People Democratic Party PDP presidential candidate in the February 25th election. Justice James Omotosho, in a ruling, awarded a 5 million naira fine each in favor of Atiku Abubakar and the Independent Corrupt Practices and Other Related Offences Commission, ICPC, making it a 10 million naira fine against Keyamo. Justice Omotosho, who described the suit as frivolous, vexatious, and abuse of court processes, directed that the fine should be paid at 10% per annum until the cost is finally liquidated. The order followed an oral application by court for Atiku, Benson Igbanoi, and that of the ICPC Oluwakemi Odogun, asking for costs after the matter was dismissed. Keyamo, who was also the spokesperson of the dissolved Tinubu-Shetima Presidential Campaign Council (PCC), has filed a suit marked FHC-ABG-CS-84-2023 on January 20th. In the application, he had sought an order compelling the Economic and Financial Crime Commission (EFCC), ICPC, and the Code of Conduct Bureau (CCP) to probe and prosecute Atiku Abubakar. Keyamo based his action on the grounds of claims by one of Abubakar's aide, Michael Achimugu, that between 1999 and 2027, that's 2007, when he was vice president's aide, he, Achimugu, conspired with ex-president Olusegun Obasanjo to rip off the country using what he termed special purpose vehicles. The ex-minister filed a suit against the 72-hour ultimatum he gave the three investigating agencies a lapse. He alleged that Atiku Abubakar was in violation of Section 18, subsection 2 of the Money Laundering, Prevention and Prohibition Act 2022 and Section 96, subsection 1 of the Penal Code, hence unqualified to contest in the February 25th polls. But Atiku first the defendants, through his lawyer, filed a notice of preliminary objection seeking for an order dismissing the suit for being incompetent, lack of locus standi, want of jurisdiction, and for non-disclosure of reasonable cause against him. The EFCC, ICPC, and the CCP, in their separate preliminary objection, also challenged the competency of the suit and jurisdiction of the court. Delivering the ruling, Justice Omotosho held that he had two issues for determination, and that was whether the suit was frivolous and whether the relief sought by Keyamo could be granted. The judge, who said the jurisdiction of the court would be determined, also said that the locus standi of the application would also be looked into. Locus standi is the capacity of a party to institute an action. It interrogates what is the business of the plaintiff with the defendants. The need for proper locus standi is to prevent busybodies from instituting a suit and restraining them from wasting the time of the court. That was what the judge said. He went further to say, or he said through the court, he said Though the court did not say that ex-minister did not have the right to write statutory agencies to investigate Atiku Abubakar, but that he had not shown why he was affected by Atiku's action. A citizen of a country has a right to report crime, and that cannot be an infraction on fundamental right of any person. But the complainant is to complain to the statutory agencies and not to drag the first defendant with the agencies to court to seek an order to compel the agency to investigate the suspect. Justice Omotosho held that investigating authorities that had the disciplinary power to investigate any case and to know if such case would warrant any prosecution or not, citing previous cases to back his decision. The law is that the court cannot compel investigating agencies to perform their discretionary powers. The judge who read Kiyamo's letter, wherein he gave the investigating agency 72 hours ultimatum to investigate Atiku Abubakar, said the Court of Appeal in one of its decisions cautioned public officers against abuse of power. He said that it was unheard that a citizen would give statutory agencies 72 hours to investigate and prosecute an alleged offense, and immediately after the 72 hours, an action was filed. The question is 72 hours sufficient for the investigation and conclusion of action of this nature? The answer is no. Omotosho, who said that Kiyama did not even give a reasonable time for the statutory body to act before filing the suit, said that this means that the action was filed in bad faith. He said that the case was frivolous and an abuse of court processes. He went further to say that the plaintiff, who is supposed to be a lawyer, would think that a suit compelling a statutory body will succeed, giving 72 hours. The plaintiff should know that these agencies are at liberty on when to investigate and when to conclude. He said Kiyamos acted as if he was an errand boy. Oh my God. He said it was high time public officers know that statutory agencies should not be used to settle political discord. The judge therefore commended the EFCC, ICPC, and the CCP for refusing to act in a way that would suggest that Kiyamo was giving them directive. A plaintiff should know that such suit will not succeed. Motosho describes suit as frivolous, vexatious, and abuse of court processes, consequently dismissed the suit. Shortly after the ruling, ICPC lawyer Odogun asked for a 30 million naira fine in favor of his client. She argued that the ICPC has been diligent in defending the matter and the time and resources has been wasted. Also, Atiku Abubakar lawyer Mr. Banoi prayed the court for a 200 million naira fine against Kiyamo, considering that his client was former vice president and presidential candidate in the last election. But Kiyamo counsel OC Uju disagreed with the two lawyers, asking the court to dismiss the application for a cost. The judge, however, asked a 5 million naira fine each in favor of Atiku Abubakar and ICPC. Meanwhile, Kiyamo has reacted to it, and here is his statement in detail. In a statement by Kiyamo's lawyer John Anetor, it reads, said earlier today, Federal High Court in Abuja dismissed the case filed by Festus Kiyamo, senior advocate of Nigeria, against the candidate of the People Democratic Party in the last presidential election, Alhaji Atiku Abubakar, over the SPV saga, principally because the court was of the opinion that the law enforcement agencies were not given enough time to commence investigation before the suit was filed, amongst other sundry reasons. Our client respectfully disagree with the reasons for the said decision because the law enforcement agencies did not indicate their willingness to commence investigation even if they were given more time. We want to establish a legal principle that the society cannot wait as infinitum for law enforcement agencies to do their statutory duties. The suit was designed to prompt the agencies to show their readiness to investigate. We are immediately filing an appeal against the said decision to the Court of Appeal as the struggle on this issue continues, which means that Kiamo is not ready to give in to whatever the Federal High Court have said, and they believe that it is the right of Nigerian citizens to, push the security agencies and also economic agencies to investigate anyone found wanting, especially in the area of money laundering or involvement in any corrupt practices. But it's quite interesting knowing that even government officials can pass through this. But guess what? Nigerians are talking more on the part of the fact that this guy was very instrumental during the Tinubu's push for presidency. But even in all of this, the law still does not respect him. The same sledgehammer that it released on those young men who filed for the court, who filed an application for the court to abort the swearing in of Bola Ahmed Tinubu as the president of Nigeria. That was the same sledgehammer that was released on Festus Keyamo. And I know that this is very degrading, considering the fact that this is a senior advocate of Nigeria, and being also that it's not just the case is not just being dismissed. He is to pay whooping 10 million naira. Most Nigerians believe that that amount is nothing to write home about, considering the fact that these guys are big boys. We know that they have enjoyed Nigeria real good in the just concluded administration. He was, I think, one of the junior ministers who oversee the affairs of a particular ministry. But be that as it may, I feel that this is a way of the judiciary telling Nigerians we are ready to work, we are ready to fight. And I am hopeful that this kind of thing will be experienced in the appeal court, in the presidential election petition court, whereby they will reach a consensus that will shock the entirety of Nigeria, both the executive, both the legislature, and every other person who has undermined the weaponry of the judiciary. Because right now, most Nigerians have given up hope. They believe that no matter the kind of document that Peter Obi will present in this time and also in this moment where already Bola Ahmed Tinubu has been sworn in as the president of the country, no amount of judicial move will be able to hoist him out. But I feel that the judiciary, amidst all of this disbelief by Nigerians, can still concretize their position on issues that are as transparent as the one currently going on in the PEPT or PEPC right now. However, what's your position on this? For me, for most Nigerians, they call it kind of disgrace on the part of Festus Keyamo. Others believe that it's a way of retraining him to know when to speak and when not to speak. What's your standpoint on this? Let's interact in our conversation. Thank you very much.